Hey guys, we're talking about design patents for the next little while. Not many people actually do design patent work. Some people dabble in it, and if you do so, just read up on it before you do. But design patents are a very interesting area indeed. There's just a great deal of economic sense and advantage that you can develop by having a design patent portfolio. I think is apparent from the Apple Samsung litigation, at least. There are only a few sections of the patent code that are specific for design patents, and Section 171 is one of them. It says, and it sounds a lot like 101, whoever invents any new, original, and ornamental, as opposed to useful, design for an article of manufacture may obtain a patent therefor. So, the focus of a design patent is on the appearance of the article. Design patents only protect what is in the claims and which is also what is shown in the drawings. In that sense, they're very specific and cabin to what's in those drawings, the particular pattern even that's shown in the drawings. We'll take a look at a couple of design patents in a second, but as you'll see, the scope of them is fairly narrow. However, if it covers the exact product that you'll be selling, it doesn't matter how narrow it is, does it? It'll still be useful economically. So I figured we should take a look at a couple of design patents. This is a nice illustration of a couple points. This is obviously a screwdriver. The design here is on the handle of the screwdriver. The reason I know that is that the dashed lines are covering the shank and tip of the screwdriver, and the fact that they're dashed means they aren't part of what is being claimed. Like I said in the last slide, what is claimed in a design patent literally is what is in the drawings. The claim reads what is depicted and shown or something like that in the attached figures. So that's called an omnibus claim, but that's how you claim designs. And for that reason, the drawings are exceedingly important. You notice there are no reference numbers. There is no description to which they would be relevant. So they aren't included here. Again, this design only covers the handle. Use whatever shank you want. It could be a Phillips head. It doesn't matter. What the dashing means just that isn't part of what is being claimed. This can include designs like this. This was one that was obtained by Apple on the interface, the shape of the screen for their iPhones. And I'll show you some pictures later of how innovative that was at the time. It's very hard to put yourself back in someone's shoes at that time. I have the benefit of having been in my own shoes at that time. So I can show you a couple figures that I think will make you realize how really innovative that design was. You notice the solid parts, the dashed parts, it's the relation on the screen on this article of manufacture that they're claiming here. And finally, here's a design patent that I worked on. A little bit hard to tell from my angle. Oh, no, it's still fine. So you may have, if you like candles, you'll appreciate that some candles are made of a special kind of fatty acid, and they form these large crystalline bodies. They aren't just on the surface, they penetrate through the whole candle. And these large crystalline bodies are actually very characteristically shaped depending on which fatty acid you're using. I know more about candles than I ever thought I would because of the work I did on this and related applications. But you'll see something striking at first about this patent, and that is that everything is dashed. So what does that mean? That nothing is part of our design? No. What we would argue, and what we did argue, and it is in the prosecution history, is that those, even though it's not the exact pattern of those randomly seeded crystals, instead it's that kind of crystal. So this exact pattern won't replicate itself, but these kinds of crystalline bodies will be present. Therefore, we didn't want to limit ourselves. We were trying to capture that crystalline pattern on the surface of a candle, and this is the way we chose to do it. I don't think this was ever tested in litigation. I don't know where it would have gone had it done so. But yeah, I think it's an interesting example. Not one you'll see in many textbooks, I predict. So let's talk a little bit. I alluded to the issue between utility and ornamentality previously in passing. Let's go a little bit more into it. So, if the design claimed in a design patent is dictated solely by the function of the article, the patent is invalid because that is not the subject of a design patent. It has to be the design has to be ornamental for it to be patentable subject material for design patents. Just as with copyrights, and you may have been thinking about copyrights in the back of your mind as I was speaking, because the principle there between ornamentality or creativity, whether it has utility or ornamentality, is the same sort of consideration that you undertake here. Slightly different rules, but really it's conceptually the same. Here it is if the design claimed is dictated solely by the function of the article. So it's a little bit harder here than in copyright, but I don't want to belabor copyright, but you're right to think of the parallels there. So just to talk about it a little bit more, you can have ornamentality within utility. An example we just had up was the screwdriver, right? That obviously has utility. It's a tool. But the ornamentality wasn't the driving factor in the utility of that device. So how can you tease those two apart? When the appearance is dictated by the use or purpose, or if the design is essential to the use of the article, it cannot be the subject of a design patent. That should be the subject of a utility patent. Designs are for the ornamental design of an article of manufacture. So I just want to give you a couple of factors that are commonly considered when assessing utility. These needn't be belabored, but I did want to let you know about them. So this, whether the protected design is the best design, and that means from a utility perspective. If it's the best one and has the best results, well, doesn't that imply that it has a particularized utility rather than ornamentality. Similarly to asking if the protected design is the best is asking whether others are worse. Whether there are related utility patents. Sometimes those utility patents will describe the what you're asserting to be ornamental features in terms of utility, and that often doesn't go well for the design patent holder in that instance. This is straightforward. If you tout that feature of the design as having utility, and again, just really that's a restatement of the whole analysis, whether the design is clearly not dictated by function. So, bluntly, I'm not going to ask you a question on design patents, but I wanted you to be aware of these factors. So, design patents have to satisfy the statutory requirements for patentability just like utility. There's anticipation, there's obviousness. And rather than talk about the prosecution, it's easier to talk about litigation, because that's often where it's tested, and for design patents, it's a lot easier to do that. So for anticipation, use an ordinary observer standard. And would that ordinary observer find the designs to be substantially the same? This discussion is in the book at 807 and 808. Rather than just read the discussion they have, I would commend those pages to you. But recognize that in this sense, it's almost like the person having ordinary skill in the art is the ordinary observer. They've been replaced by the ordinary observer in the anticipation analysis. A case that talks about that is the Apple v. Samsung case. Again, it's just astounding the impact those things can have on the overall, just the massive amounts of money that have changed hands in that case is mind-blowing. It's how much we spend on phones, I guess. So, obviousness of design patents, as you can imagine, is a judgment call of a judgment call. Establishing obviousness in a utility matter isn't terribly easy. As you know, well, as you're about to after I make the video, which is next, then you have to make some judgment calls. You have to put forward some arguments and be compelling. But at the end of the day, it depends on how the judge sees it. It's not always going to be readily apparent. It is geometrically worse with design patents because you have two very not bad, but difficult judgment calls to make. Here we go. So it is still conducted within the framework of Graham. The questions, however, within the Graham framework are slightly different. So for design patents, the question is whether the claim design would be obvious to an ordinary designer of such items. So now we're talking, that is the person having ordinary skill in the art for an obviousness analysis. And you undergo a two-step process. You identify a single prior art reference that is basically the same as the claim design. And you could think of that in different ways. Really what's that saying is identify the closest prior art and then identify related secondary references to combine with the primary reference to arrive at the same design. So the principles of KSR, if not some of the particulars, apply equally here. Some of the discussion of utility-specific things like obvious to try and likelihood of success aren't relevant. But there's still, just as in any 103 analysis, has to be some suggestion or motivation, either inherent in the field or in the art, or explicit within the references, to combine those. So here you then have to make arguments saying that one of ordinary or a designer or ordinary designer would have made those jumps. It's almost like chemical structural obviousness in ways, but it's a very that's actually quite interesting if you think about it. They're very similar. The chemical molecule is unique in the same way as a design is unique. Sorry for rambling on a bit, but this just struck me. So it makes sense that they would have a similarly structured assessment for their obviousness. That's something to think about. But as you can see, this is a nuanced argument with lots of design considerations. I waved my hands because I don't understand what design considerations really are. I'm just not that guy. I have other, whatever. I have other interests, but that stuff is magic to me. How people come up with things that actually work and I intuitively know how to use them is amazing. And that look good, I don't even know. It's amazing. It's all amazing. So infringement is also different for design patents. The same rights are granted to design patent holders, which is to say you can exclude others from making, using, offering for sale, selling, or importing into the U.S. the patented design. But in an infringement analysis, the court or jury should look to see if the accused article embodies the patented design or any colorable imitation thereof. And that's to a reasonable observer. Ordinary observer, I'm sorry. The case that talks about this most extensively is the Egyptian goddess v. Switzer or Switzer case on page 823. It gets into this in extensive detail. I'm not going to belabor it here. Lies. I'm going to belabor it here. Okay. This is the test as articulated by that case. If, in the eye of an ordinary observer, giving such attention as a purchaser usually gives, two designs are substantially the same, if the semblance is such as to deceive such an observer, inducing him or her to purchase one article, supposing it to be the other. Whew. That's a difficult call, right? You can just see how hard that is. It does emphasize the fact that this is an article found in Commerce. And for those of you who have had fundamentals of IP, I'll ask the question, pause a moment, and then answer it, I guess. Does this remind you of any other enforcement paradigm or a test for infringement? Well, I'll tell you, this is very similar to trademark infringement. What you're looking at here is whether or not an individual involved with commerce would be deceived into buying one over the other. And it's not exactly the same because there are differences, be deceived as to a different thing, the sorts of goods and services, right? In trademarks here, it's just that you're deceived into choosing the other design. But it is, there's some analogous analyses that could go on there. And that's another reason to study IP together, is that you get that overlap between in some of the areas between the concepts that are being addressed. And here, the Gestalt analysis is appropriate. It's the overall appearance that's considered, not an element by element basis. So it's a little bit different. It's very different in that regard from utility patents, where each element of the claim is identified and compared against the accused product or process system, whatever it might be. But with regards to designs, it's like it's the whole overall appearance. In part, I think that makes complete sense, because what would you the elements of a design aren't always apparent. And what one person would consider an element of a design is not what someone else would. So you'd have to have a claim construction on what the elements were and then what the elements really looked like, or you do this, right? You do a gestalt instead of an element by element analysis. Prior art actually does play a role in an infringement analysis for design. And I bring it up because it's so different from US. And this is like a foreign jurisdiction to me, so I called it utility practice, US practice. Oh boy, long week. Remember that if you're assessing infringement in a utility case, you don't look at the prior art, you look at the claims and the accused product. The prior art is for assessing validity, not for assessing infringement. Here, however, I mean that was sort of that's a bad question because I just answered it. But generally, prior art shouldn't play any role. You're trying to assess what the hell the claims mean and whether or not the accused product falls within those claims. However, in the design patent analysis, it plays a special role. If prior art is very close to the claim design, then slight differences become more important. And there's a similar principle in trademark law, actually. But this makes sense, right? Because if the prior art is very close, that indicates that an ordinary observer would recognize that such distinctions are worthy of patentable protection, and that's why one attributes more significance to those slight differences when the prior art is very close. Now we're going to step into very briefly design patent damages. So in addition to normal remedies that we've discussed in the last lecture, a design patent holder can elect to recover the extent of the infringer's total profits. So this is a design-specific provision. And it can really be very significant. You remember, we're talking about Apple and Samsung in some of these design cases. Total profits for selling that device? Whew, that is very different from total profits attributable to the benefit of that device, right? Or the functionality of that device. That's a hammer and a half. So I want you to look at this for just a minute. This is my, I'm old slide. But on the left, you see all the diversity of designs. I had a lot of those. I was a dork. But I didn't have a razor, but I had a bunch of them. And after 2007, when the iPhone came out, it got a little bit more uniform. I think you can see readily how quickly Apple was copied. Now you go into a phone store, you can't find anything. I mean, maybe you'll find some white phones or a gray phone red if you're lucky, but I mean, it's just not, it's kind of boring from my perspective. This is the design that was protected. So it really is that overall shape of the screen. Not so much the button, not the button, but the ear hole, the shape of the screen, and that'll be interfaceable, part of the screen that shows things that the user can touch. So Samsung, in this instance, lost to Apple on claims of design patent. So what should the damages be? Again, you can get the total profits. So it's a two-step process to determine whether or not you get what total market you get. So the first step is identifying an article of manufacture, because that is what the design patent covers. So you have to identify that portion of the device that's attributable, what portion of the profits, are attributable to that article of manufacture as defined by the claims of the design patent. And that total profit is what the patent holder is entitled to. And additionally, the profits must be due to or attributable to the design rather than other aspects of the article of manufacture. Now, you can imagine in the case of a cell phone where the display is the protected article of manufacture, one could argue that a very large portion of the profits were due to that design attribute. Article of manufacture, rather. It was attributable to that. So, the article of manufacture may either be the end product sold to the consumer or a component of that product. And, of course, how you define it really makes a big difference. And to my knowledge, and my knowledge may not be complete, but to my knowledge, the court hasn't articulated a test for that yet. Here's another example that I pose to you just as a sort of thought experiment. This pattern is a protected design. I took it from a Federal Circuit case. This pattern was useful for the outside of cushions. Not useful, but it was used ornamentally on the outside of cushions. For porch sets of outdoor furniture where all of the cushions are made with this pattern, what would you do? What portion of the profits from that porch set, which probably includes a table, 4 chairs with these patterns on the cushions, and say a chaise lounge which has this pattern on its cushions. So how much of the profit would you attribute to this pattern? It's an exceedingly difficult task, as I think you can appreciate. So, as you can see, this is the ornamental design for the chair. And it's an interesting thing to think about. I don't know that there's a clear right answer. It depends. There's no way of answering it now. We don't have all the facts we need regarding the market and how consumers view the claims or the article of manufacture at issue. Whether there's whole bunches of factual issues that A, preclude me from asking you about it on an exam, but B, just preclude hypos because there's so many factual issues we can't really address here. We don't know about them. So, but I think you can appreciate this as just something on a chair. It could really become complicated very quickly.